Hi guys, so let's start with case study number 8. Question first. Yes, so they are asking whether the arrest of Mr. Kataria by the Assistant Commissioner is legally valid. For this question, we have to refer the case study. Okay, so yes, as you can see here, the Assistant Director does not have any arrest warrant against Mr. Kataria, but in the belief that Mr. Kataria might become untraceable later on, he arrested Mr. Kataria on 21st September 10:30 in the morning, and instead of taking him to the judicial magistrate, the Assistant Commissioner took Mr. Kataria to special court on 22nd September at 4:15 p.m. So after traveling for 6 hours to the court. Okay, so if you see the legal provision, if the director, deputy director, or the assistant director has, on the basis of material in his possession, has a reason to believe that any person has been guilty of an offense punishable under this act, he may arrest such person and shall as soon as be inform such arrested person on the grounds of such arrest. Okay, so assistant director has the power to make the arrest, but some students might get confused because since he does not have arrest warrant, can the assistant director arrest Mr. Kataria? Yes, in special circumstances, the assistant director has a power that he can arrest the person if he is going to evade the application of law upon him. So it is clearly given that assistant director has a belief that Mr. Kataria might become untraceable later on. Since he is going to get underground, or he is going to be untraceable later on, it is a special circumstance, and under special circumstance, assistant director can arrest a person without arrest warrant, but he has to be produced before the so presenting of an arrested person before the competent authority. Every person arrested shall within 24 hours be taken to a special court or judicial magistrate or metropolitan magistrate, as the case may be, having jurisdiction, provided that the period of 24 hours shall exclude the time necessary for the journey from the place of arrest to the special court. Okay, so whenever a person is arrested, he has to be presented to the court within 24 hours of his arrest, but those calculation of 24 hours will exclude the time taken from the journey from the place of arrest to the special court or the magistrate court. Okay, so the time taken for journey from the place of arrest to the special court will be excluded, but he has to be presented within 24 hours. So let's see what is the time taken in the given case study. So he was arrested on the 10:30 in the morning on 21st September, and he was produced to the special court on 22nd September at 4:15 p.m. That is, so the total hour comes to 29.45 hours. 29.45 hours were taken for producing Mr. Kataria after his arrest, but they have given that there is a 6 hours of travel. So 29.45 minus 29.45, or you can say 29.75 minus 6 comes to 23.75 hours. That is, within 24 hours he was presented before the special court, so there is no violation of legal provision. Okay, so whether the arrest of Mr. Kataria by the assistant commissioner is legally valid? Yes, the arrest is legally valid in all the aspect, because in the given case the assistant director is authorized to arrest without a warrant in special circumstances, and a arrested person is presented before the court after 23.75 hours, that is within 24 hours after excluding the traveling time of 6 hours from 21st September 10:30 morning to 4:15 on the 22nd September. Okay, so his arrest is legally valid in all the aspects. So option D is the correct answer. Can the adjudicating authority grant an extension to the resolution professional in the present case for the purpose of completion of fast track CIRP? Okay, So they have asked this question. Yes, so as you can see, the application for fast track corporate insolvency resolution process was duly filed with the authority and a resolution professional was appointed for the same. The resolution professional, finding it difficult to complete the resolution process within the prescribed time limit, discusses the same with the creditors in the committee of the creditor committee, due to which the committee instructed him to seek an extension from the adjudicating authority by way of passing a resolution to give the effect of instruction with 68% of the voting share of the creditors who are also in majority in terms of numbers. So if you know what is the exact percentage approval which is required for extension of the fast track CIRP process, this is a very easy question for you. So as you can see, legal provision requirement of 75% of the voting share. In case of a normal CIRP process, 66% voting share is okay, but in case of a fast track CIRP process, 75% voting share of committee of the creditors is required. The resolution professional shall file an application to the adjudicating authority to extend the period of fast track corporate insolvency resolution process beyond 90 days if instructed to do so by the resolution passed at the meeting of the committee of the creditors and supported by a vote of 75% of the voting share. In the given case, only 68% of the voting share was taken in committee of the creditors. Okay, so since only 68% voting share is obtained, which is less than the required voting share, that is 75%, it is not in compliance of the legal provision. So let's see what is the yes. So can the adjudicating authority grant an extension? No. No, the extension cannot be granted as the requisite percentage approval is not obtained. Question third. Who can be considered as the beneficial owner with respect to the deposit made of 2 lakhs in the bank account of driver directly as an advance salary for 10 months as per the provisions of Prevention of Money Laundering Act 2002. Okay, so for answering this question, you need to know what do you mean by beneficial owner. Okay, so who is the beneficial owner? Beneficial owner means a person who, whether his identity is known or not, for whose benefit the Benami property is held by a Benamidar. Thus, a person who enjoys the benefit of Benami property is the beneficial owner, and it is the Benamidar who holds the property for the benefit of the beneficial owner. Okay, so here what has happened is that out of sale proceeds of 4.20 crores, sorry, from here, since in meantime, as they have received a show cause notice from ACIT, hence in anticipation of the search, they settled the cash by making an advance payment of 12 lakhs in cash to Impacts Elevators, which is going to install the lift in their current house, and remaining 2 lakhs were deposited in the bank account of their driver directly as an advance salary for 10 months. Okay, so according to the case study, since there was an search, there was hint of search taking place in the premises, the person paid his driver advance salary of 10 months of amount 2 lakhs. So since the amount is deposited in the bank account of the driver, it is for the benefit of the driver, correct? So in the given case, 2 lakhs were deposited in the bank account of the driver, okay, for not for the benefit of Kataria, but for his own benefit, because his salary was paid as an advance. So if you can see, who can be considered as a beneficial owner with respect to the deposit made of 2 lakhs in bank account of driver directly as an advance salary. So beneficial owner is the driver. Okay, so driver is the beneficial owner. So let's see whether I'm correct or not. Yes, so D is the correct answer. Driver is the correct answer. Lot of people might get confused because they might think that a driver is only holding cash for his boss, that is Mr. Kataria, but since he what they have given in the case study, that he has been paid his salary, that is he is not holding the amount for the benefit of Mr. Kataria, but he is holding 2 lakhs in bank account for his own benefit. Hence, beneficial owner means a person who enjoys the benefit of a Benami property is the beneficial owner. Since he is enjoying the 2 lakhs which are deposited in his bank account, he will be considered as the beneficial owner. Next, who can be considered next, who can be considered as the Benamidar with respect to the purchase of piece of land for 4.12 crores from Noor Muhammad Khan out of the funds diverted from KAL. I want to note here that the similar question, not same, similar question was asked in December 21 exam, but the core of this question was changed. That is, here they have given yes, as you can see in case study, what they have given is that the piece of land which Mr. Kataria selected for his farmhouse was purchased for 4.12 crores in the name of his wife, Mr. Pushpa Kataria, from Noor Muhammad Khan out of the funds diverted from KAL. Okay, so this was a Benami property which was registered in the name of his wife, Miss Pushpa Kataria. So we are asked the question, who will be considered as, yes, who can be considered as Benamidar with respect to the purchase of piece of land for 4.12 crores from Noor Muhammad Khan out of the funds diverted from KAL. So for this you must know what do you mean by Benamidar. So Benamidar means a person or a fictitious person, as the case may be, in whose name the Benami property is transferred or is held, and includes a person who lends his money. Thus, any person who intentionally lends his money or allows his name to be used for transferring or holding a Benami property is also a Benamidar. So, since in the given case the plot of land of 4.12 crores was purchased out of the diverted funds from KAL, we can also know it as it was out of the unknown sources. The land was purchased in the name of Miss Pushpa Kataria. So, since the Benami property is registered in the name of Miss Kataria and she is holding such Benami property for the benefit of her husband, Mr. Kataria, she will be considered as Benamidar. Okay, so let's see what are the options. Who can be considered as Benamidar with respect to the purchase of piece of land? Since the property is registered in the name of Miss Kataria, she will be considered as, Miss Kataria will be considered as Benamidar, and Mr. Kataria will be considered as beneficial owner. Although it is not asked, I am just clarifying. So option B is the correct answer. Miss Kataria will be considered as Benamidar. Question 5th. With respect to the enactment of legislation based upon the promulgated ordinance by the government, what shall be the relevance of the Commission's opinion on the same for the government? This is not at all related to the case study. This is an independent question. So they are asking whether the Commission's opinion is binding on the government. So very easy question. So as you can see, option A, I think, is the correct answer. It's the discretion of the government to make reference to the Commission prior to making any law or policy on competition or any other matter. So yes, option A is the correct answer. It is not binding on the government to accept the Commission's opinion, but as a matter of good policy making or as a matter of principle, the government at its own discretion can make a reference to the Commission prior to making any law, but such commissions, that is Competition Commission of India's opinion is not binding on the government. So option A is the correct answer. That is, it is the discretion of the government to make such reference and it is not binding on the government. So option A is the correct answer. So in this way we have completed case study number 8. I will be attaching the link of this PDF which contains the legal explanations and provision for the answers of MCQ in the description box. So don't forget to check out the description box. Thank you.